Okay, well, we will get started. Um, Thank you for coming, everyone, and welcome to our Rockefeller College Spring Lunch and Learn series. So this is going to be fairly similar format to what we did in the fall for the 2024 election series. We're going to hold them a little bit less frequently, so we're shooting for a bi-weekly basis. In about 2 weeks, February 18th, we're going to have a talk on energy and climate policy with one of our public administration professors, Michael Saxonus. Today, we are going to talk about birthright citizenship, and we're privileged to be joined by Dean Novkov, who wrote the book on birthright citizenship, co-authored with Carol Nackendorf, American by Birth, Wong Kim Ark, and The Battle for Citizenship. So I'll pass it over to Dr. Novkov in a moment, but just to refresh everybody on the sort of ground rules, usually we have our speaker talk for about half the time, and then we spend the other half on Q&A. So if you have any questions while Dr. Novkov's speaking, I encourage you to put them in the chat and I'll read them to Dr. Novkov. And of course, you can also use the hand raise function if you want to also speak. So with that, I'll pass it over to Dr. Novkov.
Thank you so much, Connor. Thank you for taking on the moderating job again this semester. And thank you so much to Renee for getting everything set up so that we can do this. It's certainly going to be an interesting time. I'm very happy that so many of you have agreed to spend your lunchtime with us. We in the college will do our best to provide you with timely analysis and information about the things that are going on in the United States and around the world. So we've got some very exciting stuff coming up. But today, my job is to get us started off with a discussion of birthright citizenship. As most of you know, there was an executive order issued right at the beginning of the Trump administration. It's hard to realize it's only been a few weeks because there's been so much going on. But this was one of the very first things that President Trump did. The executive order purports to empower the U.S. State Department to deny Social Security numbers and other legal documents to children who are born to several classes of individuals in the United States who do not have permanent legal status in the United States. Now, this executive order goes against what most people have understood to be the broad principle of birthright citizenship in the United States, or the idea that if somebody is born within the geographic boundaries of the United States, that person is automatically granted citizenship. So there was immediate litigation among many quarters challenging this executive order. The ACLU brought suit on behalf of 3 different groups and individuals in different states. And I believe at last count, we had 22 state attorneys general, plus the city of San Francisco and a few others filing suit against this executive order. The state of play on the ground right now is that a federal district court judge in Seattle issued a temporary restraining order, and there are now proceedings underway to determine whether that is going to convert into a long-term injunction. This judge, who's a Reagan appointee, has been on the bench for quite a long time, had some fairly sharp words for the government in issuing this TRO last week. He said, "I've been on the bench for over 4 decades. I can't remember another case where the question presented was as clear. Where were the lawyers," he said, "when the decision to sign the executive order was made?" And he claimed that it boggled his mind that a member of the bar would claim that the order was constitutional. So what is going on here? Why does it seem to be so clear to so many members of the legal community that this executive order attempts to exercise a power that the President of the United States does not, in fact, possess? To answer that question, I'm going to have to go pretty far back in US history to explain how it is that we got to this principle, which was enshrined in the Constitution in the famous case of Wong Kim Ark in 1898. If you go back to the beginning of the United States as a constitutional republic, one of the first things that Congress did after the passage of the Constitution was to pass the first Naturalization Act in 1790. This act established that naturalization was available to any alien being a free white person who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years. At this time, of course, though, the United States was very much interested in bringing more people to its shores and to getting more citizens. So it was pretty much assumed that people who were born in the United States were entitled to some form of citizenship. This created a little bit more tension as issues of slavery permeated in the early republic. So Missouri's entrance into the Union raised the question again by barring the in-migration of, quote, free Negroes and mulattoes intending to settle in Missouri. This clearly ran afoul of the Comedy Clause. So you had New York and Vermont, and other legislatures arguing at that point that African Americans who were born as free people were citizens of their states and therefore that they were entitled to US citizenship. Ultimately, Congress compromised, as they were very fond of doing during this period. They allowed Missouri to keep that clause, but warned them not to enact any law that would impair the rights of citizens from other states, including citizens of color. So throughout the rest of the antebellum era, Black citizenship remained somewhat vexed. There's a fantastic book by Martha Jones that looked at how this played out on the ground, the East Coast. But things kind of reached a head in the infamous decision of Dred Scott versus Sanford, in which Chief Justice Taney put forward the proposition that African Americans were not and never could be citizens, and claimed that descendants of Africans were not constituent members of this sovereignty. We then had a war over this. And ultimately, over the course of the Civil War, Abraham Lincoln and the Republicans became convinced that simply banning the expansion of slavery was not going to be enough. And then ultimately, just that ending the institution of slavery was not going to be enough, but that African Americans had to be protected in their access to citizenship. In 1866, the Civil Rights Act was passed by Congress and granted citizenship to all persons born in the United States and not subject to any foreign power, excluding Indians not taxed. Opponents actually objected to this as being too broad, and Andrew Johnson vetoed it. He complained that this provision comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as Blacks, people of color, Negroes, mulattoes, and people of African blood. This convinced Congress that amendment was the only solution. There was a vigorous debate in Congress about how far to extend birthright citizenship, a principle that, again, predated the 14th Amendment by quite a long time. And ultimately, Congress settled on very expansive language. They spoke specifically about the implications of using broad language and recognized explicitly that this would grant citizenship to the children of Chinese immigrants and to the children of Romani people living in the United States, among others. And they chose nonetheless to go forward broadly. So the language that they ultimately reached, a very famous language, is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So it's a fairly clear constitutional provision. As far as constitutional provisions go, they're not always that clear. But you begin to see a little bit of debate early on about exactly what this is going to mean and what citizenship of the United States is going to mean. So there is some controversy early on about what subject to the jurisdiction thereof is going to mean. There's a throwaway line in the slaughterhouse cases decided in the 1870s, claiming to exclude from the birthright provision children of ministers, councils, and citizens or subjects of foreign states born within the United States, but that was not at all the center of that case. So you began to see jurisprudence developing more directly around the clause itself a little bit later. The first major case involved a Native American, John Elk, who had left his tribe. He wanted to register to vote in the state of Oklahoma, but he was denied based on the claim that he did not, in fact, possess citizenship. Horace Gray, a Boston Brahmin and Joseph Story admirer, wrote the majority opinion for the court. Gray was a noted scholar of sovereignty, and he was a very well-respected legal analysis. He had actually co-authored a hatchet job on Dred Scott and its theory of citizenship. So the court felt that he was the man for this moment. And he issued a ruling. He wrote an opinion ruling against John Elk, claiming that Native American tribes were, quote, in a dependent condition, a state of pupillage resembling that of a ward to his guardian. Under those conditions, individuals could not change their alien and dependent condition without a reciprocal act on the part of the nation. So John Elk, as a member of this tribe at birth, had not been born a citizen, and he could not simply push away his tribal identity and therefore transform his own status. That teed up the question squarely about what to do with individuals not identified in this particular provision as Native Americans. What do we do with other people who are born in the United States? Are they entitled to citizenship? Wong Kim Ark was a Chinese man. He was the son of a couple who lived in Chinatown. The best we've been able to determine is that he was born in San Francisco in the early 1870s. His father was a merchant, and therefore in the United States under a provision that allowed merchants to live in the United States. Chinese exclusion was imposed early in his lifetime. And under these principles, which got more and more restrictive as time went on, only merchants and registered laborers, and very few of them, were permitted to remain in the United States. And Wong Kim Ark himself did not fall under either of these categories of people permitted to be in the United States. He did not have a certificate as a laborer entitled to be here, and he himself was not a merchant. At this time, Chinese people who lived in the United States often led these transnational lives where they went back and forth to China to spend time with extended families. Wong Kim Ark was no exception. So on one of his trips back to China, he visited his family in China, returned to the United States in 1895, and he was stopped at the border and denied entry. And this conflict gave rise to one of the greatest landmark cases in US history at a time when the Supreme Court was doubling and tripling down on clearing a path for Jim Crow. So this court, the Fuller Court, was very, very hostile to people of color. Important to keep that in mind regarding this case. In fact, in 1896, shortly after Wong Kim Ark was prevented from entering the country, the court decided Plessy versus Ferguson, allowing a state-enforced segregation under law. When the case finally reached the US Supreme Court, it was exceptionally well prepared. There were over 300 pages of briefs filed on both sides. And the author of this opinion was none other than Justice Gray. He was the author, again, of the Elk case, wrote for the majority there. Justice Gray went through an analysis of sovereignty and an analysis of citizenship, going all the way back to English common law, which had established birthright citizenship. He cited cases actually going back to before the passage of the 14th Amendment. And he leaned on Justice Story's analysis that, quote, persons who are born in a country are generally deemed citizens and subjects of that country. He emphasized the 14th Amendment's general language, and he talked specifically about the Elk case, saying that it was it was not the same issue because Native Americans are different as having, in his words, alien and dependent status. By his reading, Congress is responsible for establishing the naturalization process, but the Constitution sets the baseline for citizenship. And Wong Kim Ark's Chinese ancestry was not a valid reason to deny him citizenship. In his analysis, Congress could have addressed that when it amended the Constitution, but opted not to do so. And under that amendment, Wong Kim Ark was clearly entitled to citizenship. So that was where things were left on the field in 1898. So what do we make of birthright citizenship? This core principle has really stood without significant challenges since that decision. If you look at public opinion polling on the issue, there is little broad support for getting rid of birthright citizenship generally, though there is some support for limiting it to the children of legal residents. But whatever the contemporary controversy over birthright citizenship, the history seems pretty clear. Wong Kim Ark was, as I've noted, decided in a time of rising nativism and exclusion based on race. Policy development at this time increasingly restricted and excluded Chinese individuals. Yet, there was never any attempt made to limit or strip the citizenship of children of Chinese immigrants who were born in the United States. So there are two arguments about Wong Kim Ark not necessarily being as broad as the decision would seem. The one that has picked up a little bit of support among legal scholars, although it is decidedly the minority view, is the idea of consent, and that Congress could have the power to alter birthright citizenship because citizenship is a form of mutual consent between a polity and the individual who is subject to the jurisdiction of that polity. This theory rests pretty heavily on Elk versus Wilkins. I'm not persuaded by it, largely because the justice who wrote Elk versus Wilkins is the same justice who wrote Wong Kim Ark. I do believe if you sit down and read these opinions together, particularly Justice Gray's discussion of Elk versus Wilkins, he distinguishes that case and makes it clear that the principle excludes Native Americans, but then is very broad other than that. The other thing that comes up though here, whether we're talking about the executive branch or Congress, is what about the children of individuals who are in the United States without legal status? Wong Kim Ark, as I've mentioned, was the son of a merchant who was in the United States legally. His wife was in the United States legally under the principle that merchants were permitted to have their wives with them. However, by 1898, when Wong Kim Ark was decided, the status of illegal alien existed. That was established by the Geary Act shortly before then. The court considered the constitutionality of the Geary Act and upheld it. And when you're talking about illegal immigration in the late 19th and early 20th centuries, a lot of the time you're talking about the Chinese. They were particularly suspected of engaging in illegal immigration. Women who immigrated were suspected of doing so not as part of a valid marriage, but as a part of being a prostitution ring. And there was an increasing problem with individuals claiming birthright citizenship on the basis of being the child of an American citizen and presenting paperwork that was falsified. The US government was very agitated about this practice, and there's certainly some evidence that people were engaging in it. Indeed, Wong Kim Ark's own sons had difficulty entering the United States on a few different occasions because they were suspected of not actually being his sons. Wong Kim Ark himself once had difficulty re-entering the United States after a trip to China and attempted to show the decision as a possible way of confirming he was entitled to enter. Yet, despite all of this anxiety about illegal immigration and about individuals gaining legal status through being in the United States illegally, there was never any serious congressional or executive effort made to deny citizenship on this basis. And Congress was certainly engaging in a lot of other activities to try to control immigration with the full collaboration and support of the executive branch. So for that reason, if we were to look at this executive order, whatever you might want to say about it in doctrinal terms, or however you might want to read the language of the 14th Amendment, the history itself is pretty darn clear. Even if you could make an argument about Congress having this power, I think that's a difficult argument to make. But it is exceptionally difficult based on this history to make the claim that the executive branch can do this unilaterally. So that is what we are seeing. That is what I expect to see as this question makes its way up through the federal courts. To go away from this principle would require overturning of more than a century old legal precedent that has driven U.S. Citizenship practice during that entire period and has prevailed through serious episodes of U.S. xenophobia and hostility toward immigrants. So it remains to be seen what is going to happen. I would anticipate that this question will eventually reach the U.S. Supreme Court. And then they will need to get into this and figure out what they are going to do. But it is a really, really tough uphill legal hill to climb to make a strong argument that the executive branch has the authority to unilaterally change the nature of birthright citizenship in the United States. I'm sure people have questions, so I'm going to stop there and not indulge too much in talking about jurisdiction and what that means, but I'm happy to take your questions.
Yeah, so once again, for those who joined late, we certainly encourage you to put those questions in the chat so I can read them. Due to the volume of interest we've had in this talk, we actually have a couple of questions that were given to us in advance, some of which Dr. Novkov has already answered, and some of them a little like just kind of touched on. So the first question I have here for you, Dr. Novkov, did the floor debates by U.S. senators prior to the ratification of the 14th Amendment lend insight into whether or not the 14th Amendment was meant to clarify only citizenship status for freed slaves?
It's quite clear. That was explicitly discussed during these debates, and there was the proposal that it really be limited to the descendants of free slaves. That was not the proposal that ended up winning. There was a clear principle there to go the other direction and frame that right in very broad terms that included anybody born within the borders of the United States.
Great, thank you for clarifying that. We have another question here about Trump's sort of intentions. So this question asks, is Trump trying to end all birthright citizenship or only birthright citizenship for the offspring of individuals who are here illegally?
My read of the executive order is that somewhere in between. He is certainly targeting the children of people who are in the United States without legal status, but it includes people who are on student visas, for instance, and some other categories of individuals who are here in the United States, not necessarily exhibiting an intent to stay here permanently.
We have one final one of these questions in advance, then we'll go to Michael Klein's question. But this one asks, what are some productive actions that can be taken in opposition to Trump's efforts?
Um, I, we're getting into a little bit of political advice here. I may not be the best person to do that, but I do think it is important if you are looking at what is going on and you believe that laws or constitutional principles are being violated, that you make that known. You can talk to friends, local political actors about this, but it is also important to contact your members of Congress and let them know that you are watching what is going on and that you object to the ways that things are going.
Great, thank you. So we have an audience question here from Michael Klein. He writes, the executive order refers to citizenship as a gift, not as a right. And he wants to know what you think about that.
That's an interesting framing of citizenship. It definitely does not resonate in American history. As I've noted, the principle of birthright citizenship by location, jus soli, goes very far back in English common law. It has roots that precede the foundation of the United States, and it has been thought of in terms of a right for quite some time. So I do believe that is a problematic framing of this principle.
Okay, I'm just checking to see if anyone has their hand raised. While we wait for more questions, Dr. Novkov, I want to ask you well, an ambitious question here. What do you think, how do you think the Supreme Court might rule on this? Like what judges would vote for this interpretation of the naturalization clause, and which ones do you think might vote against it?
That's an interesting question. I mean, if you look at what people are saying in social media, you will see people sometimes saying, oh, well, you know, Trump appointed 3 justices to the court. It's a very conservative court. We know that it's a 6-3 split. So all of these things are really just going to go through in the way that the administration would prefer. I'm not at all convinced that that is what will happen here. As I've noted, allowing the executive branch to change citizenship unilaterally would be a real shift in this principle. And it seems like it might be a bridge too far for most, if not all, of the justices on the court. One justice I think would be interesting to watch on this issue in particular is Justice Gorsuch. As most people know, he is often identified as one of the most conservative justices on the court. And other than Thomas and Alito, he probably is the most conservative justice on the court by most measures. But he is very interested in these questions of jurisdiction and sovereignty. And he has been an opponent of some of the racially motivated interpretations of jurisdiction and sovereignty that went through in that period of the Fuller Court in the early 20th centuries, particular opponent of so-called insular cases, which determined that the Constitution and constitutional rights did not fully apply beyond the geographic boundaries of the United States. And he has claimed openly, he thinks that those decisions should be overruled. So I would be very surprised to see him landing on the side of allowing this executive order to stand.
Okay, thank you. Let's see, do we have anyone else here? Okay, well, we continue. Oh, no, we have a question here. It looks like from Joseph Zumbo. So Joseph asks, can an executive order overturn a constitutional amendment, or does the executive order claim children of the undocumented are not subject to the jurisdiction of the USA and therefore not under the 14th Amendment?
Yeah, it's interesting. The government actually just posted their long reply brief today. I did not have time to go through it in detail yet to see exactly what arguments they are making. I know that there are a couple of claims that they're putting out to try to get there with this executive order. They are not at this point claiming that the executive branch can overturn a constitutional amendment. They are claiming that Wong Kim Ark does not actually cover the territory that the executive order addresses. So they're making arguments about jurisdiction, claiming in particular that people who are in the United States illegally are not subject to the jurisdiction of the United States. There's also another argument out there that's, I think, even more far-fetched, that individuals who are in the United States illegally are some kind of form of invasion. And the longstanding principle of birthright citizenship does have a carve out that if you have an occupying force in a country, the country is not then required to acknowledge the citizenship of individuals who are part of that occupying force. But again, both of these are pretty far-fetched.
So following up on that, do you think that the Trump administration is sort of just testing the waters and just seeing what they can't do for their sort of comprehensive immigration reform?
I think it's always hard to kind of figure out what exactly Trump is trying to do. I do know that this issue was very prominent in his campaign. He talked about it a lot. He's been talking about it for some time. There was discussion actually during his first administration of issuing an executive order along these lines, and that ended up ultimately not happening. So I do think that among some of the people who are working on this issue within the administration, there is an interest in testing boundaries, seeing how far it can go, but it could also be, I think, reasonably read as a kind of red meat response to his supporters. Throw that out there. If that is part of what's going on, right? You can think about it as a political action that doesn't actually have that much cost to it. Because if you throw out something that by most people's analysis is blatantly unconstitutional, but is sort of a piece of red meat that your political constituents want to see, you know, you can throw that out there, get credit for having taken the action. And then this is going to have to grind through a lot of legal process. It will have to go through, there will probably be court rulings in a couple of different circuits before the US Supreme Court gets a hold of it. So it could be, we could be waiting until next fall or even next winter until the US Supreme Court issues a ruling in this case. So the political benefit can be reaped among the supporters. The order itself may never go into effect, and by the Supreme Court gets around to saying, no, you can't do that. Everybody will be moved on to something else at that point.
Great, thank you. Yeah, I always struggle to interpret the Trump administration, what they're getting at, so I appreciate that. Again, we still have 25 minutes here to the audience. I know it's a somewhat of a technical policy debate. Dr. Novkov, out of curiosity, in the period between 1896, when Wong Kim Ark is decided, up to 2025, have there been any other major conflicts or interpretive debates over this segment of the 14th Amendment, or not really?
Nothing major, nothing major. There was one case in, I believe, the 1940s where there was an attempt to push on this a bit, and it did not get far at all. It is simply something that has been presumed to be a very strong red line. Again, despite the fact that there was a lot of other restriction on immigration going into effect at around the same time that the decision was rendered. I mean, one thing that actually fueled the very strong anti-immigration movement of the early 20th century was the political reality that once immigrants came to the United States, their children were going to be entitled to citizenship. So that's an argument that you sometimes see among people pushing for ever more extreme restrictions on immigration in the early 20th century. If you let these people in, their children will be citizens. And some people would say, oh, eventually we're going to have a Chinese person as president of the United States. There's nothing to stop it.
Thank you. All right. So we have a question from Catherine Brink. So she writes, can we ask other questions than birthright citizenship? Oh, this is just to all of us, I guess. Musk's non-elective, not born here, who has, yeah, I mean, if you'd like, I suppose we want to mainly keep it on topic, but legal questions, sure.
I'll do my best. We are in a very interesting period right now. There is a lot going on. And a lot of it is stuff that really hasn't happened before. So policymakers, legal experts, people inside the government, people outside the government are, there's a lot of effort to understand what's going on and figure out what kinds of legal lines have been crossed. Right now, a lot of the experts that I follow, the legal experts, are talking about this idea of impoundment. The idea being that once Congress has formally appropriated funds and directed the executive branch to spend those funds, the executive branch cannot then turn around and say, oh, no, we're actually going to spend this on something else. And that this is a principle that goes back to the 1970s. There were some significant restrictions put into place over the executive branch in the wake of Watergate to restrict some forms of autonomy. There are some sort of gray areas that exist between the power of Congress and the power of the executive branch. But when we're talking about expenditures, that is territory that is fairly firmly lodged in Article 1 as a responsibility of Congress, which is why you're seeing quite a lot of legal pushback to some of the things that the administration is attempting to do. With Musk himself, there's an additional concern or problem, which is what exactly is the legal status that he is claiming to have to do the things that he is doing. Many of you may have seen that there's this claim that Musk is unilaterally canceling USAID. Again, this is pretty far out there in terms of how the Constitution works, how authorization has to be sought to do these kinds of things, and the coordinate roles of Congress and the executive branch. So I'm not terribly confident in predicting anything in this very uncertain time. But one thing I can predict very confidently is that US federal courts are going to be handling a lot of litigation involving the actions that are being taken by the executive branch right now.
So I'll ask another question. If we don't hear back from anyone else with more, we can, end things a little shortly here. So this is kind of just a follow-up about this whole impoundment debate, which I found rather vexing. I feel like I remember Trump making a similar argument about impoundment back in his first term. Has this argument been in currency at all amongst like the Federalist Society at all? It doesn't sound very conservative. Or is this just kind of like some sycophants who have found themselves in Trump's inner orbit?
Well, this is really coming very directly out of Project 2025. The entire document is more than 900 pages long. There's a lot going on in there. And I think that people who were looking at it before the election were often looking at the parts of it that were kind of really visible and controversial about limiting reproductive freedom, abolishing the Department of Education, et cetera, et cetera. And we know that there was a lot of controversy over those things. But one of the core ideas in Project 2025 was really to centralize power and authority within the White House and take away a lot of the autonomy of administrative agencies and just concentrate that power and basically use Treasury, use OMB as a tool to create compliance across the executive branch, across the entire administrative structure. That was obviously a really difficult issue to explain in a political setting. So I think people weren't necessarily that focused on it, but clearly that piece of Project 2025 is very much at the heart of how the Trump administration intends to remake executive authority and to remake the federal government itself. And there are questions, right, about how far the executive branch can go unilaterally in changing the way that that administrative structure works.
All right, great. Thank you for answering that. We have a question from Molly now. So she asks, she writes, some media pundits and influencers have framed this order as a test of whether the Supreme Court would allow Trump to violate the Constitution. In your opinion, what factors might protect other amendments if the Supreme Court allowed this order to stand?
What factors might protect other amendments if the Supreme Court allowed this order to stand? Not much, because this is a pretty big one. And again, if the court were to overturn or substantially narrow Wong Kim Ark, that's pretty much a signal that anything is fair game. We've already seen this court engage in a lot of reinterpretations of other sections of the 14th Amendment. We've seen that in particular with respect to the Equality Clause. With liberty, we're seeing this court do some major restructuring of religious free expression and establishment of religion in the First Amendment realm. So, there's a lot in motion. Is this an intentional test of the limits of how far the Supreme Court will go to align itself with Trump? Again, I'm not necessarily convinced that there's some seven-dimensional chess game being played out. I do think that a lot of it is about feeding the base. But I think one thing we do need to remember throughout all of this, I'm a political scientist, so I can say this, the court is a political actor. It's a different kind of political actor than Congress or the executive branch, but it is a political actor. Whether you love John Roberts or hate John Roberts, he does understand himself to be an institutionalist who is interested in preserving the power and authority of the court. One thing that's very consistent about him is that when he is writing opinions for the court, he is very careful to shepherd the court's power and to deal the court into political controversies and empower the court. Whatever happens with the Trump administration, I don't see that changing. And I think that he would be extremely reluctant to hand over to the administration the authority to issue definitive interpretations of the Constitution. And with something that has been around as long as Wong Kim Ark and is so embedded in American constitutional principle, that's exactly how Roberts and several members of the court might perceive such an executive order.
Our next question here is from Sherry Dankinson. So she writes, while the courts consider these issues, i.e. impoundment and the injunction, birthright citizenship, will nothing else happen unless Congress takes action?
Well, again, if you have one branch of the government that is really seeking to empower itself, our constitutional system depends on the other two branches being willing to defend their turf. I do think that the courts are going to defend their turf, whether it is something that they perceive as a direct infringement on their power or on their authority to issue definitive interpretations of the Constitution and of statutes. With regard to impoundment, I think we're going to see injunctions, quite frankly. However, as you point out, right, some of this is going to come down to Congress being willing to say, hey, we have our Article 1 powers too, and the executive branch cannot go against our Article 1 powers. It remains to be seen, I think, whether Republicans in Congress are feeling more beholden to Trump in political terms, or if they might worry that eventually, as tends to happen in American politics, the pendulum will swing the other way. And, if you allow a Republican president to walk in the door and say, all right, no more USAID, can then a Democratic president walk in the door and say, all right, I'm impounding all funds dedicated to this particular Republican institution and priority. So I think we're gonna have to wait a little bit to see how this plays out.
All right, so we have another question here from Guillermo Martinez. So it is, what was the debate in the US Senate on this section of the 14th Amendment prior to its enactment? Would that debate open door to having SCOTUS review the citizenship questions and subsequent court decisions on birthright citizenship as an extension of the original legislative intent behind the citizenship section of the 14th Amendment? So the debate.
Again, I think if you look at the Congressional Globe, you look at the reporting on these debates, there was a minority position that the clause should be written narrowly. There was a lot of debate about this. The clause was written broadly, and people, whether they agreed or not, understood that birthright citizenship was going to include more, far more than just the children of individuals who had been held in chattel slavery, that citizenship was going to follow this very broad principle that was deeply rooted in English common law. So yeah, I think if you want to do an originalist analysis seriously, if you want to look at the history seriously, you have to take that debate seriously. And there was a winning side in that debate, and there was a losing side in that debate.
Right, so we can have our last call for questions here. Going once, going twice. Let me just check hand. Okay. All right. Well, we can end things there. So thank you so much to Dr. Novkov for your presentation today and for answering our questions, not only on the naturalization clause, but a whole host of emerging constitutional questions and debates. So for those interested in following the lecture series going forward, our next talk is going to be on February 18th. So that's a Tuesday, 12 o'clock, same time. And we're going to be joined by Bill Saxoness to talk about energy and climate policy. So thank you so much, everyone, for joining us, and we'll see you next time.
Thank you, everybody.